2 hours and then have this be only half a
Well,
meeting.
isn't the information the
Sure,
start of the
should I
show?
slide
Not you,
over?
Mr. Crump.
Yeah, you should probably slide over a bit.
I think that's the most important part.
Okay.
See, we're good.
Oh,
We're good. That's
that's
actually
good.
good.
Oh, that's actually
good.
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 All right.
Pride. Okay,
Today
just take
is April the 8th, and today we're going to do the courts and political parties in the next hour for our review for the AP US Government and Politics test. Okay, first we'll look at courts, and we want to do the organization. Now there are 3 parts in our organization. We start down here at the bottom where we have the district courts, and we're just going to look at the federal system over here for now. But we have over here federal district courts. Now, there are 2 things we need to remember about federal district courts. These are courts of original jurisdiction. And what does that mean?
Not appeals cases.
All right. This is where we hear the trial for the very first time. So, when somebody is tried or charged with a federal crime, your first appeal, your first case would be listened to in a federal district court. Okay? These are the trial courts right here. So trial courts involving federal issues. If it's not a federal issue, you'd be over here on the state court side. What would be a federal issue, Stephen?
Like anything involving 2 states.
All right. Anything involving 2 states. Somebody's gone from one state to another. You're a fugitive of justice.
Anytime you bring federal law.
All right. And federal law would be an example of what?
Robbing a bank is against federal law.
And why would that be?
Because the
Yeah,
FDIC
federally
ensures
Right.
that.
Because they're insured by the Federal Deposit Insurance Corporation. So that would be a federal crime. And the FBI, the Federal Bureau of Investigation, would be investigating. Okay, if you don't like the decision, you appeal to the next level, which is the Circuit Court of Appeals. Now, we have in the United States the 12 circuits, plus the circuit for the District of Columbia. And what would you do here? Eric?
I'd like to check for mistakes that were made in the original case.
All right, so you're looking for mistakes. You're not retrying the case again. Who listens to those mistakes?
3 justices.
How many?
Yeah, 3 justices.
All right, 3 justices or 3 judges, and they listen to the mistakes as a panel, and they would decide whether there were mistakes by a 2-to-1 or 3-to-0 decision. Okay, so what if they find a mistake? What happens?
Usually it gets sent back down, which would be done.
All right, they send it back down to the Federal District Trial Court. They don't retry it themselves. They send it back saying you cannot make this mistake, or you need to throw out the evidence, or whatever you needed to do. So they make the decision in 3 judge panels. They send it back if there was a mistake that they found. What if you don't like their decision?
Appeal to the Supreme Court.
All right, so you appeal up here, and we notice a dotted line. So we have the United States Supreme Court, and they have original jurisdiction, and they have appellate jurisdiction. Now, what kind of a case would they do original jurisdiction over? Listen to the original case.
Conflict between 2 states.
All right. That is their most common one. If 2 states have a disagreement over water rights or whatever, they would listen to that case in an original jurisdiction type situation. However, they would also listen to cases originally involving ambassadors or other things that related to that kind of stuff, foreign affairs. But most of the cases are cases they listen to on appeal. appeal from our circuit court. Now, we have writ of certiorari. What does that mean? Right?
The judges have to take a vote on whether they want to hear the case or not.
All right, so we have a vote to determine whether they want it to come. That's why this is a dotted line and not a solid line, because they only listen to the cases that they want. They don't listen to any other cases. So, if they like your case, then they will issue a writ of certiorari saying that they want to have your case brought from here up to the Supreme Court. And so that is our highest court. How many judges are on the Supreme Court? 9 judges. Who is the Chief Justice? All right, John Roberts. And how long are they on the court? All right, lifetime terms. Okay, so that is our organization. Okay, next section. Let's go to the powers and history. First of all, we have the J Court. Now, let's find our section here on that. The J Court. John Jay, first Chief Justice of the United States. What's the significance of that court? What kind of things that they do that affect us today? Remember? Remember when they first met, there weren't any cases. So what did they do?
Went out and tracked, wrote my cases.
All right, they rode circuit. They went from each of the 13 district courts and heard cases there until there were cases that came up to the Supreme Court. But some of their precedences, no advisory opinions. They said, we are not going to talk about any case unless we have an actual case before us. So they must have a case to tell what their opinion is going to be. Second, they were the first to declare a law constitutional. And they're the first court to have a ruling overturned by an amendment. So we have the 11th Amendment, which overturns the Supreme Court. Yes? You come over here and get one of these.
Is it supposed to be today? I think it was supposed to be.
I thought it was supposed to be next week.
It's next week. The things just started today. Suppose. Sorry.
Okay, well, I'm not familiar with that. So, but I know it's coming up. All right, let's go to our next justice, and that is Justice John Marshall.
Doesn't say.
Now, remember, John Marshall, he's our next justice in the history. He is famous as being one of these midnight judges, appointed by John Adams at the last minute to have all the Federalists go on the courts. Some of his accomplishments: he is the justice who added to federal power. He made the courts strengthen the power of the federal government in so many ways, because he was a very strong Federalist. Some of the ways he did: Marbury versus Madison, which is our case that gave us what?
Necessary and proper.
No, that's this case.
Dang it.
McCulloch versus Maryland. Marbury versus Madison is judicial review. This gave the courts the power to listen to cases of constitutionality involving the other branch of the government. So Marbury versus Madison was the first case to declare a law unconstitutional. Okay? Very important. McCulloch versus Maryland. That's what, Joel?
That's where they decided, that's where he said that the government could do anything that was necessary and proper.
So this gave us the implied powers of Congress. So Congress can now have implied powers to do things that are necessary and proper. This is a case that involved the national bank. So should we be able to have a bank, even though it doesn't say in the Constitution that Congress can make a federal bank? Okay. Then we have the case of Gibbons versus Ogden. Gibbons versus Ogden talks about what? How did that give the federal government power? Yes,
So the government can regulate interstate commerce.
all right, so anything that is involved in interstate commerce can be regulated by the federal government. And then Fletcher versus Peck, another important case here for the court, and this is the first time it declared a state law unconstitutional. So we're declaring federal laws unconstitutional with Marbury versus Madison, and state laws unconstitutional with Fletcher versus Peck. Okay. Then we have the Warren Court. So we have Chief Justice Earl Warren, and he is big on the rights of the accused. He was the Chief Justice in the 50s and 60s. Anybody accused of rights, being accused of violating the Constitution, he is on the court that did that. This is what we call an activist court, a court that goes beyond the mere reading of the law. Now, some of his precedents that you should know: Brown versus Board of Education, one of the most important Supreme Court cases. Andreas, what's that about?
Separate is not.
No, separate can never be equal on school. And Miss Linda Brown, who wanted to go to a all-white school. Okay, we also have Matt versus Heil. This is a case of an exclusionary rule, which said that when you search for something, you must have a fair search. And if not, we will exclude it from the evidence at the trial. Then we have Gideon versus Wainwright, which is our case of the right to have an attorney. Okay. And Miranda versus Arizona. Of course, this is the famous case where you need to be told your rights before you can be made to say anything against you. So, Mr. Brown, we talked about court locations. You don't need to know all that stuff, but those are our major court eras. The current Chief Justice, John Roberts, he's been justice since 2005. The immediate predecessor was William Rehnquist. And William Rehnquist is kind of famous because he's the one who had the case of United States versus Lopez, which was a monumental case in what area?
It would involve like a gun, but
It involved guns in schools, good. And it said for the first time that the Interstate Commerce Clause could not be used to regulate guns in schools. So this turned back the power of the federal government and reversed it, saying that you just can't say everything that has been involved in interstate commerce can be regulated. So he said guns cannot be used in schools. Guns cannot be regulated by the federal government for schools. It had to be the states. So this was a victory for states' rights. Okay, let's go to the next section, which talks about the decision-making process for the courts. Okay, so we'll start here with selecting the cases. Now, the court terms, number one is selecting cases, so just put select cases in the box to start with. We have the court term. The court term begins in October, the first Monday in October. and will go to the end of June. How many Supreme Court justices does it take to accept a case? All right, very good. I'm going to call that the rule of 4. So, during the summer, before the term starts, they'll look over all the cases. If there are 4 justices that want to look at the case, then the case is brought up. They then issue the writ of certiorari, sometimes called a cert petition, to have the case brought up to the court. Now, we said there are 2 types of jurisdiction, the original, the appellate, and original between 2 states and ambassadors, so we already talked about that. So the next thing is written arguments. They'll ask each of the lawyers to write up their arguments, and these are called the written briefs, and the specifications, they have to write them on a certain size of paper, and everything is pretty exact in how they have to do that. So they do that over the next few months, send them up to the court, and then we have the oral arguments. Now, oral arguments, that goes on for 30 minutes. Each side gets 30 minutes, after which time your case has been submitted. Here's a picture of the court today. The newest justice, Elena Kagan. Got your justices in a pretty even divide here. With the conservative justices being Scalia, Thomas, Roberts, and Alito, and your more liberal justices being Breyer, Ginsburg, Sotomayor, and Kagan, and right in the middle is Justice Kennedy, who is the Supreme Justice who decides which the case will be on a lot of cases in 5-court decisions. The next is the case conference. This is where the justices meet in a case conference in a secret meeting room. Nobody's allowed in there but the justices. They meet in their room. They just discuss the case in reverse seniority, so the first justice to discuss the case would be Elena Kagan, and then they move to the other justices who tell how they feel about the case. And they vote, and then they assign the writing of the opinions. Now, if the Chief Justice is in the majority, he will assign the writing of opinions for the majority opinion. The Senior Justice of the others will assign that opinion. So, they select, then they have a majority opinion, a concurring opinion, dissenting opinion, and in between, they're lobbying for votes. So after they have taken their initial vote, then anybody in the minority who would write the dissenting opinion can go and try to convert somebody to side on their side. If they do, they take the final vote, and this may change, but if not, nobody changes. This is the same as before. Then the opinions are announced and published, and it becomes the rule of law. Okay? So that is the process there. Okay? The next one is talking about relations with other changes. The court can be 2 types. It can be judicially active, which means what? Judicial activism. What does that mean when they do that?
That they're more willing to change laws.
All right. They're more willing to overturn precedents. They're more willing to change the laws. They're more willing to make judgments on the other things. Okay? If they have judicial restraint, what are they looking at?
Just more conservative, sort of. Just...
All right. They're very hesitant to overturn a precedent. they restrain themselves to stick to the original whatever. We have also another group of people who are looking at changes, and we have those who are original tent people versus those who believe in a living constitution, that the Constitution should change and adapt all the time. So you have original tent, that we should only do it like the Founding Fathers said. Is that conservative or liberal? It can be conservative. And living Constitution, it can change and adapt. The thing you have to remember is that these could be used by either side to justify whatever. I mean, people who believe in regulating abortion say, all right, we want the government. Does it say in the Constitution that government regulates abortion? No. But do they want government to regulate abortion? Yeah. So they want the court to be active and involved and do something about all these abortions that are happening. Whereas the opposite, the people who have choice or believe in choice say, well, government should stay out of my own personal affairs. So it can be used by either side, depending on how they want to use it. Okay, and we have the term stare decisis. What does stare decisis mean?
Let the decision stand.
All right, let the decision stand, or we're going to go by precedent, what happened before. And so as a result, stare decisis simply means they're going to stick with what's come before and use that as a guide to make our current decisions, stare decisis. Okay, also in that box we want to put the officers of the court. We have 4 main officers that we want to put down, and the first is the Attorney General. Okay, what does the Attorney General do?
He is the chief. He runs the judicial department.
All right, he runs the judicial department of the cabinet, which we call the Justice Department. So he's in charge of enforcing laws related to crime and other instances of justice. Okay, then we have the Solicitor General. What does the Solicitor General do?
Argues cases for the U.S. government before the Supreme Court.
All right, very good. So we're arguing cases before the Supreme Court. What does the U.S. Marshal Service do, or the U.S. Marshal?
That one I don't know. I'm not sure Tommy Lee
Okay.
Jones.
The U.S. Marshal, he enforces, he works to arrest people who are in violation of the law. They protect the courts. They make sure there's law and order in the courtroom themselves. Okay? So, that would be that section. Let me see if we've got any others here. Okay, let's just go through here. The next one is the selection process for a judge. Okay, that's number 5. We're going to start over here with the selection committee. Okay, selection committee. Who's on the selection committee? Who's the number 1 person? Good. Attorney General. And we have the president. The president sits there and says, all right, we want you to choose who is going to be new justices, new judges. We want to know. Now they send it to a, we can also have the Solicitor General on this committee. It's the Assistant Attorney General. Okay, next we go to the candidate evaluation. Who evaluates these candidates?
Judiciary.
Where do they send it to? Up here. American Bar Association. They'll take and evaluate to see whether this candidate here has been doing a good job as a lawyer. And we'll send it over there and make sure that they are looking good. Then we have senatorial courtesy. What does that mean?
So that's where the the senator from the new justice's district gets to say if he likes the new justice or not.
And what if they don't like it?
Then they usually just have a news.
What do they call
the blue
it?
slip. That's right. That's right there. Good job on this.
All right, they call that a blue slip. Okay, so they're going to take and look at a blue slip. They simply issue a thing saying they don't like it. Does that mean the candidacy is dead? No, but it means it could be limping here. So, especially if it's of the same party as the president, that generally would have been dead if that were the case. All right, then we send it over to the U.S. Senate here, and the Judiciary Committee, the U.S. Senate, will have hearings on this person. So, who has input into that?
Interest groups.
All right, interest groups can testify. The media can be there to look after it. We can have political parties. We can have just normal, everyday people. Oh, I forgot also, they have to have an FBI check up here on candidate evaluation. All right. It passes that. You can go to the next level, which is the full U.S. Senate here. And again, we can have interest groups. We can have all the media. They can all give input into the Senate. And finally, if they approve, they take the oath. Chief Justice administers the oath, or their preferred justice. And they are now a member of the Supreme Court. The White House staff also is on the selection committee up here. So we've got all those people there. All right, so that's how you become a justice of the Supreme Court. All right, any questions on that? All right, let's go to our last one on the bottom, political parties. Okay, get my political parties out here, just press the pause on this for a minute.